I'm Nikki Jovicic from Lookupstrata, and I'm also the Managing Director of Tower Body Corporate. I'm speaking with Jarad Maher, partner at Grace Lawyers. In February 2023, the Queensland Government announced upcoming changes to the Queensland Body Corporate legislation. The new laws passed Queensland Parliament on the 14th of November 2023, and changes began on the 1st of May 2024. Some of the headline changes that have received quite a bit of attention include the right to tow, increased protection for pet owners, and decreased rights for smokers. However, a little mentioned change is now sending waves of concern through the Queensland strata industry. Are common seals required or not? Are current contracts compliant? We asked Jarad Maher to explain the changes and what they mean to body corporate committees and strata managers. Thanks for joining us, Jarad.
You're welcome. Great to be with you.
Now, can you explain to us what was previously in place?
So previously, the Body Corporate Community Management Act had Section 34, which has now been repealed, but Section 34 required each body corporate to have a common seal. Separate to the requirement to have a seal, the regulation modules also specified how a body corporate is to use the seal. That contained two elements. Firstly, a default rule, which was execution by two committee members, one who had to be the chairperson or secretary, and those committee members had to sign as witnesses to the affixing of the seal. So essentially everyone had to be in the same room to do it properly. The seal had to be applied, and the two committee members, one being the chairperson or secretary, had to then add their signatures and confirm essentially that they had witnessed the seal being applied. So that was the previous requirement. What the amendments have actually done is remove those requirements entirely. So both Section 34 and Section 236 of the standard module, Section 225 of the accommodation module, have been repealed in their entirety.
Okay, so is this a positive change? Does that make things easier?
Look, overall, it's a positive change in the sense that it provides bodies corporate with a great deal of flexibility as to how they execute documents. Previously, it was quite difficult, particularly with committee members that wouldn't be in the same location as the seal, to actually execute in the technically correct manner under the old requirements. Quite often, bodies corporate wouldn't comply with the actual requirements. A document might be circulated by post, the seal would be applied, and then the other committee members would execute at different times and at different locations. That was technically incorrect. So it overcomes some of those hurdles under the previous regime. So I think overall, it's a positive move to relax the requirements for execution and give more flexibility to bodies corporate in this space.
And are there any difficulties with the changes that came with that as well?
Yeah, in my view, I think the amendments go a little bit too far in the sense that they've removed any guidelines to a body corporate and committee as to how a document is to be executed. Now, removing the requirement to apply a seal to a document is one thing, and that was actually what the QUT's report into the property law amendments had recommended to government. These amendments go a step further and now remove any type of default rule or guidelines as to how a body corporate is to execute documents. So that might give rise to its own difficulties in terms of there being a lack of guidance. And we can also see some murmurs in the industry about, well, how do we now execute documents properly if there's no default rule?
So how do we overcome these difficulties?
So from a day-to-day perspective in terms of resolution, setting aside titles office documents for just the moment, in regards to any resolution of a body corporate that's going to potentially require entering into a document or execution of a document by the body corporate, it would be very wise, in my view, for a body corporate to specifically nominate the authorised persons who are allowed to sign the document. No longer is there a requirement for the seal to be affixed, but the resolution should specify who has the authority, and it can be a single individual. It doesn't need to be two committee members. One of them doesn't need to be the chairperson or secretary. There's no default rule. So I think it's important that each and every motion considered by a body corporate that may require execution of a document nominates the person or persons that are authorised to sign that document on behalf of the the body corporate. As far as the Titles Office requirements are concerned, there hasn't been any update to the Land Title Practice Manual currently in relation to what the Titles Office will consider acceptable for lodgement. Presumably, there's two options available to the Titles Office. The first would be to essentially have a default rule in the practice manual which removes the requirement for a seal, which might follow the previous requirement in terms of the committee members executing a document, one being the chairperson or secretary. So essentially the previous default rule, but without use of the seal. And then in other circumstances where a resolution provided for a different manner of execution, there's always been an ability for the body corporate to lodge a copy of that resolution with the document that's being lodged in titles to evidence that there was authority for the document to be signed in a different manner other than the default rule that applies. Alternatively, the Titles Office could take another approach, and that might be to simply require a copy of each and every resolution that authorises lodgement of any documents in the Titles Office. So that might be another way of the Titles Office dealing with the new amendments to the legislation, and simply saying that with each and every lodgement, a body corporate must lodge a copy of the resolution which authorises that document to be lodged. So those are probably the two options. Until such time as we know the approach that the Titles Office are going to take, it would be advisable for bodies corporate to continue to execute any documents for lodgement in the Titles Office in the previous manner, and that's execution under seal by two committee members, one of whom is the chairperson or secretary. As mentioned, there's always been an ability for the body corporate to execute in a different manner by an ordinary resolution. So if that was the case, then a copy of that resolution always needs to be lodged in the Titles Office to evidence that the person signing had the authority of the owners at a general meeting. Perhaps another thing that could be looked at, not just in respect of Titles Office executions, but in respect of executions generally, perhaps the body corporate could look at passing a blanket resolution authorising execution of documents in a particular manner in respect of anything where a specific motion doesn't provide otherwise. So essentially, it would be a case of the body corporate effectively creating their own default rule, like they did under the old legislation, perhaps without use of the seal, but by two committee members. And then the body corporate could rely upon that blanket resolution for any future executions, and would always be able to change it by individual resolutions that provide for execution in a different manner. So that might be one practical way of bodies corporate dealing with the issue, is passing a blanket resolution to deal with execution where there's no specific resolution authorising execution in a different manner. But I think that you'd be wise to make sure that each and every resolution contains authority for who is to execute the document, and that's going to be the best evidence for someone to look back to make sure that the document was validly authorised by the body corporate.
And looking long term, Jarad, just to resolve any confusion that's out there, would we expect some sort of a statement to come through with some clarification?
My understanding is that the Titles Office are currently weighing up the options. I haven't received any information which would confirm which way they're going to go, but they are, as far as I'm aware, updating the Land Title Practice Manual. To date, that hasn't occurred. I would have thought that that would have been perhaps lined up to commence at the same time as the regulation modules were amended, removing those relevant provisions about execution on the 1st of May. That hasn't happened, and I'm aware that the Titles Office are looking into the matter. So I'd expect them to look at publishing the new requirements soon, and that will give us much clearer guidance about what will be acceptable for lodgement with titles, whether we need to produce a copy of each and every resolution that authorises lodgement of a document with the Titles Office, and then essentially give the body corporate the flexibility to do away with the seal at that point in time.
As a strata manager, what do we have to do right now?
Everyone should keep up to date with any publications from the Titles Office, and in the absence of any confirmation as to what they'll accept, then for existing bodies corporate that have a seal, don't throw it away, hang on to the seal, continue to use it, particularly for land titles documents, until they publish the new requirements. Once they're known, we'll know what to do with titles office documents. As far as other contracts are concerned, it's probably more a concern for third parties to make sure that the body corporate have validly entered into the agreement. Those parties have certain protections under Section 311 of the Act, which says that if a document is entered into and the person entering into the document with the body corporate doesn't have any notice that there was a defect in the authority of the person to enter into the agreement on behalf of the body corporate, that they can essentially rely on entering into the agreement with the body corporate. That's more of a backup protection for third parties dealing with bodies corporate. I think you'll find that a lot of third parties will want to make sure that they cite a copy of the resolution. In the absence of seeing a seal and 2 committee member signatures on the document, they're likely going to request a copy of the minutes to make sure that the body corporate had the requisite authority and that the contract is valid and binding on the parties.
Okay, well, thank you very much, Jarad, for providing us with a bit of clarity around this confusing matter.
If there's provision for the body corporate to execute in a particular manner, in the sense that the document is set out in a particular manner, which may have a space for the affixing of the seal, the absence of the seal is not going to invalidate the execution, provided that the legislative requirements are complied with. And the essence of them are that there's no guidance now to the body corporate about how to execute. So in that manner, my view is that each and every resolution passed by the body corporate should specify the method of execution, and the body corporate may want to do a default rule which sort of applies in the absence of specification in a particular motion. So that's my view, is that in terms of general contracts like non-land titles documents, it would be up to the actual resolution to nominate who has the authority to sign. That's the crux of it.
Keep us updated in case you do hear of anything in the future, and we'll certainly pass that on to our audience as well.
Will do, Nikki, no problem.
If you gained value from this video, please hit like and subscribe to our YouTube channel. If you're looking for information about parking, strata insurance, defects and more, head over to lookupstrata.com.au or sign up to our free weekly newsletter via the link in the description box below.